All right, pause right here. This isn't just a meeting. This is a legal minefield. A 2-member disciplinary committee is the bare minimum allowed under Rule 206A, which means this case is already walking a procedural tightrope. One wrong step, and this could turn into an appeals nightmare. And trust me, with the personalities about to clash, that risk is very real.
Chair of this hearing committee, to my right is seated John Hahn, fellow committee member. There was a third committee member who developed a personal emergency over the weekend and is not able to be here. Pursuant to Rule of Disciplinary Enforcement 206A, 2 members of a hearing committee constitute a quorum, and because of that, we will proceed with the hearing. I'd ask
Oh, good Lord. We've got a disciplinary committee hearing. A lot of people sent it to me. Zach over at Law Nerds Unite actually got me the copy of it. I haven't seen it. This should be interesting, and I got a couple other clips that I've been trying to get out, but haven't made it. We'll see if the internet holds up.
parties to introduce themselves. First, ODC.
Thank you. My name is Jennifer Tobias, and I'm representing Office of Disciplinary Counsel.
Good morning. Mark Gilson, appearing on behalf of the Office of Disciplinary Counsel.
Right, Mr. Creato.
Ron Creato, apparently the respondent here.
Thank you. And I should have said at the beginning, this matter is captioned Office of Disciplinary Counsel versus Ron Creato, number 62 DB 2024. I have a required statement to be read before we go further, and I will do that now. Pursuant to Section 89.151 of the Disciplinary Board Rules, the respondent is hereby notified that after this hearing committee makes its finding on the issue of alleged misconduct, participants are then entitled to offer any evidence which is relevant and material on the issue of the type of discipline to be imposed. The respondent is further advised that any finding of this committee as to the alleged misconduct and/or the type of discipline to be imposed is only a recommendation to the disciplinary board. The board has the power to accept or reject the findings and the recommendations of the hearing committee. If the board rejects the findings or recommendation of the hearing committee, the board in turn has the power to either increase or decrease the recommendation.
That last part? That's the nuclear option. The Pennsylvania Supreme Court doesn't just rubber stamp these decisions, they can completely rewrite the punishment, from dismissal to disbarment. So what we're watching here isn't a trial. It's the first domino in a chain that could end someone's legal career forever.
And the discipline of the hearing committee if they find professional misconduct. In the event the board finds public discipline in the form of disbarment, suspension, probation, or public censure to be appropriate, the board's decision relevant to the alleged misconduct and/or the type of discipline to be imposed is not considered a final order, but only a recommendation which is submitted to the Chief Justice of the Supreme Court of Pennsylvania for the court's deliberation. The Supreme Court of Pennsylvania, in turn, will consider the matter de novo and will issue a final order either accepting the recommendations of the board, dismissing the petition for discipline, or increasing or decreasing the type of discipline recommended by the board. In the event the disciplinary board concludes that a matter should be resolved by public reprimand or private discipline, the participants have limited rights to request review of the board's findings by the Supreme Court of Pennsylvania, pursuant to the Pennsylvania Rules of Disciplinary Enforcement. Again, once the matter reaches the Supreme Court, the court has the power to increase or decrease the discipline recommended by the board. Thank you. So at this point, I think we're prepared to proceed. Would the Office of Disciplinary Counsel like to make an opening?
So I gather the respondent, who's the attorney here, is incarcerated. That's what it looks like to me. I don't know. I haven't seen this statement.
Yeah. I'm not prepared. Actually, Mr. Chair, I'm not prepared to proceed. I'd like to request a continuance today. I'm at a severe disadvantage. I don't have the petition. I don't have any of the documents. I've been incarcerated since October 27th, so I haven't had an opportunity to participate and respond and do what I need to do here. In addition to that, there were limited resources in the facility where I was, so there was no pens available, paper, etc. So I couldn't participate in the process due to lack of resources. This is the first.
And here comes the sympathy play. I didn't have papers, pens, or phone access. That sounds compelling, but legally, it's thin ice. Courts expect incarcerated attorneys to protect their own cases, especially when their incarceration is due to their own alleged misconduct. So the question is this a real due process violation, or strategic? Delay? This is huge.
Request for continuance. I'm here at Camp Hill, right around the corner, I guess, somewhere here in Houston. This is the first request for continuance. I didn't even know about this particular hearing until Mr. Gilson approached me on or about December 5, which was my 17th date. And I was incarcerated prior to that. The judge put me in jail on a probation. I'm sorry, on a bail violation. So I've been restricted and have had limited resources available to participate.
Maybe you shouldn't have violated your bail. I don't know. Just a thought.
Set myself in this matter. I've also had limited telephone contact, which means I was not even able to reach out to try to.
If I may, I do object here. Mr. Creato's request for a continuance has been considered and denied by the disciplinary board chair.
Yeah, okay.
Thank you.
So that'd be a no.
Mr. Creato, wait, excuse me.
It wasn't aware if you received a request or not.
All right, Mr. Creato. You did make a written request for a continuance, which was addressed by the chair of the disciplinary board, and that request was denied, I believe, on Friday, this past Friday. So a further request is not appropriate at this time. The request for a continuance was made and denied, so we will proceed today.
ODC, members of the committee, ODC would make the following opening statement. On August 18th of 2025, ODC filed a petition for discipline in this matter.
Oh man, this guy's accent is thick.
The next day, August 19th of 2025,
August.
that petition was personally served on the respondent.
Once a continuance is denied, the procedural train leaves the station, and anything that happens next is on the respondent. From this moment forward, every mistake, every outburst, every misstep will live in the permanent record.
Respondent failed to provide an answer within the required time pursuant to Enforcement Rule 208B3 and Board Rule Section 8954D. All factual allegations set forth in the petition for discipline are deemed admitted. Furthermore, pursuant to Enforcement Rule 208B4 and Board Rule Section 8993D, no evidence with respect to any factual allegation in the petition for discipline that has been deemed admitted may be presented at any hearing on this matter. Therefore, pursuant to the disciplinary rules, all factual allegations submitted in the petition are deemed admitted, and no other evidence regarding those factual allegations deemed admitted may be presented. Accordingly, ODC has no witnesses to present in this hearing, and in fact will be precluded from presenting any witnesses to testify as to any factual allegations. Rather, we would move into evidence ODC exhibits 1 through 78 in their entirety. Note for the record that copies of ODC's exhibit were personally served on the respondent on December 12th of 2025, and pursuant to the hearing committee's order, ODC did not receive any objections from the respondent as to their authenticity or admissibility. With the admission into evidence of ODC Exhibits 1 through 78, ODC rests its case in the disciplinary part of the proceeding and asks the board, or asks the hearing committee rather, to make a prima facie finding that at least one of the charged rules of professional conduct had been proven. Pursuant to the rules, you do not have to specify which of those charged rules has been violated. Thank you.
Mr. Creato, do you have a brief opening statement?
This is the legal equivalent of checkmate. When allegations are deemed admitted, it means the court treats every accusation as proven, no witnesses, no cross-examination, no debate. The defense just lost the battlefield without a single shot being fired, and now all that's left is damage control.
Yes, Mr. Chairman. Very briefly, in terms of the hypocrisy of this entire proceeding, you have a rule that says an attorney may not be a witness and an attorney in a state proceeding. Mr. Gilson has participated as a witness and an attorney in this entire proceeding from the beginning to current. He appeared in front of Northampton County Court of Common Pleas, Judge Mahone, on December 5, 2025, and indicated that he was still co-counsel in this matter. He cannot be co-counsel and a witness in the same case. The hypocrisy is here. It's around. It's astonishing. In addition to that, there are factual allegations that I can defend to, the first of which is
Your objection. I object to counsel making any argument regarding factual allegations that are deemed admitted.
Oh, Mr. Creato, if there's an objection, please stop talking and we'll hear the objection.
My objection is, pursuant to the rules, counsel cannot engage in any factual statements or arguments as to factual allegations that have been deemed admitted. It is not permissible.
Again, Your Honor, I did not have the reason.
Wait, excuse me, Mr. Creato. Please wait. Objection sustained. Mr. Creato, you cannot address facts which have already been admitted.
I don't even know what facts have already been admitted. The only thing I can tell you is that your office does not have police powers, and this gentleman and his goon trespassed on my private property.
Objection. These are factual allegations that are deemed admitted.
Sustained.
Admit your past, Mr. Gilson, and stick him up.
Wait, all right, hold it. That's enough, Mr. Creato. You've worn out your welcome.
And that's the meltdown. Once a judge or committee mutes you, you've crossed from defendant into liability. This isn't just bad optics. It actively hurts any hope of leniency. Discipline hearings are about credibility, remorse, and professionalism. And right now, all three are in flames.
On your opening statement is complete.
And these two plans. The hypocrisy is a bar.
Mr. Creato, we're not going to listen to this. I'm going to ask that they mute you if you continue talking like that.
Mr. Gilson should be facing a perjury charge.
Objection.
Sustained. Right, Sarah, could you please mute Mr. Creato?
Does it in Philadelphia? DA's office?
Objection.
Sustained again.
Mr. Gilson.
Mr. Scott? Creato. No. Okay.
There we go.
All right, Mr. Creato, your comments were wholly inappropriate in the context of this hearing. And you did not listen to me, so we have put you on mute. I will ask you at appropriate times if you have comment.
There he goes.
No. Okay, I will ask you at appropriate times if you have comment, and if so, you can comment. But if necessary, we will enforce that you not be able to speak if you continue to make inappropriate comments. So with that, I would ask the Office of Disciplinary Counsel to present your case.
Thank you. I move for the admission into evidence of ODC Exhibits 1 through 78.
there was a pre-hearing order about the exchange of exhibits and requiring that a party, that the respondent, state any objections to those exhibits within 1 week. It's been represented that no objections were stated, so any objections are waived, and the exhibits 1 through 78 are accepted into evidence.
Thank you, sir. I would then ask that the hearing committee make a finding that ODC has proven a prima facie violation of at least one of the charged rules of professional conduct.
Well, at this point, I would